The Supreme Court, in a 9-0 decision written by Justice Gorsuch, said that the NCAA is violating antitrust law in the way that it compensates all of the players in college athletics. There was also a concurrence which was written by Brett Kavanaugh, all the Blue Check Brigade members who are super upset with the fact that we have this situation going on at all, that Brett Kavanaugh is a Supreme Court justice. This was one of the moments that helped to red pill me in the way that this story was covered. And I want to dive into it and talk about the larger issues at play. But in particular here, let me hit you with what Brett Kavanaugh had to say in his concurring opinion, and I am reading from this. To be sure, the NCAA and its member colleges maintain important traditions that have become part of the fabric of America. Game days in Tuscaloosa and South Bend, the packed gyms and stores in Durham, the women's and men's lacrosse championships on Memorial Day weekend, track and field meets in Eugene, the spring softball and baseball World Series in Oklahoma City and Omaha. The list goes on. But those traditions alone cannot justify the NCAA's decision to build a massive money-raising enterprise on the backs of student athletes who are not fairly compensated. Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. And under ordinary principles of antitrust law, it is not evident why college sports should be any different. The NCAA is not above the law. That is from Supreme Court Justice Brett Kavanaugh's concurring opinion in this 9-0 decision that has been released earlier today that effectively, I believe, dealt a body blow to existing NCAA issues when it comes to fair play and college athletics. So let's unpack this a little bit and let me explain what it means. First of all, the NCAA, as an existing institution that checks to see whether or not improper benefits are occurring, is effectively over. What I believe going forward is that it will seem insanely antiquated very quickly that the NCAA ever reviewed bank statements or policed whether Johnny Manziel could sell his autographs or Todd Gurley could sign and sell jerseys and shoes, and decided to suspend players based on decisions made such as those. I believe if you look forward, this effectively ends any sort of aggressive enforcement of the improper benefits perspective. Now, what this also is going to do, though, is create an entire cavalcade of lawsuits. And let me explain why. Because right now, what you effectively have in college athletics is sports socialism. Let me explain. The only two programs that make money right now on college campuses are football and men's basketball, by and large. The money that the schools make off of those programs is then rolled back into the athletic department so that all the other athletes get scholarships. In particular, football and men's basketball subsidizes all of women's athletics, which loses a ton of money, and women are getting 85 additional scholarships because no women are getting scholarships to play football. So you have football and men's basketball subsidizing basically the entirety of women's sports. If you are going to allege antitrust violations, which is what the Supreme Court has found, ultimately there are going to be lawsuits asking how payment of players and compensation of players is going to interact with the requirements of Title IX. Right now, under Title IX, all scholarship athletes, male and female, are required to be treated equally in terms of the overall number of scholarships that are given. So, if you wanted to, for instance, give $50,000, let's say, extra a year to an Ohio State football player or a Duke basketball player, men's, you would have to give that same amount theoretically to everyone else. All this decision is doing is opening up a massive legal complexity as it pertains to what is going to happen to college athletes going forward. Justice Kavanaugh's concern here and his ruling concurrence is so expansive that it basically questions the entire foundation of college athletics. In addition to Title IX, we're also going to have to find out another fascinating wrinkle here. How does this pertain to a decision as it would go theoretically towards the idea of college athlete restrictions for eligibility in general. Because remember, football players are not allowed to go pro until 3 years after their high school graduating class. Right now, every basketball player is required to wait at least a year to go pro. So, how will we analyze and set up, and I don't know the answer to this, all these age restriction requirements, which are not of NCAA creation? Remember, if you want to go pro in basketball or football, you don't have the legal right to do that right now because there are age restrictions. There have been freshmen, remember back when Maurice Clarett challenged this, who have said, hey, I am ready to go pro. I believe. In general, I agree with Justice Kavanaugh here. I am a market-based capitalist. I believe everybody deserves to make as much money as they possibly can off of their talents, particularly in the field of athletics, where your entire career could end on any given play. Okay? The example I always give is if you told me, Clay Travis, you are on track to make $100 million from radio, but your voice could stop working at any moment and you might never make that $100 million, or you could sit out for 6 months and guarantee yourself $100 million. Guess what? I'm sitting out for 6 months and guaranteeing myself $100 million. I've been nervous ever since I sold my company that I was going to die in an airplane crash or a car crash and not be able to cash in the money that I am getting now. That's all taken care of now. But I was nervous as we had these entire discussions. I'm like, man, I don't want to die in an airplane crash and suddenly my family not get all the money that is coming to us over Outkick selling to Fox. I am a capitalist, all right? I believe in people making as much money as they possibly can. But the challenge here is these are nonprofit institutions. The only people that are making a lot of money right now in college athletics are the coaches. How will you reconcile requirements as it pertains to men's football and men's basketball players who are these male athletes are the only real athletes who have value from an economic perspective? In other words, if you were running a college athletics program solely as a business, you wouldn't have any teams other than men's basketball and football. Maybe, possibly you would have women's basketball because some of those can come closer to breaking even. But the only two teams that actually make profits are football and men's basketball. The money that is made off of those schools, again, socialistic style, is rolled into supporting women's athletics and lesser interest men's teams. So how do you reconcile this ruling with all of the Title IX implications and also the age restrictions that exist, plus the name, image, and likeness, which is coming onto the horizon soon? The courts are going to have to tell us, and it is going to be messy. I think it's going to be 5 to 10 years before we figure out exactly how this is playing out. But the NCAA is so unpopular right now that they can lose a ruling 9-0, and they spent $73 million trying to defend their entire notion of amateurism. This has been an absolute long time coming.